the fact that for 2 minutes in her life, she did something reprehensible. For 2 minutes. But Miss Arias is a better person than those 2 minutes of her life. She has lived her life up until that point remarkably. And I'm asking the court to take that into consideration as well. There is no sentence that will bring Mr. Alexander back. And there is no sentence that will make these last 7 years disappear. We know that the Alexander family is hurting. What family wouldn't hurt having to go through something like this? It is the nature of this type of crime. But this case has to be judged not on a lynch mob born out of social media seeking vengeance, but on a judicial system seeking justice. And that's what we're asking the court to do. Not on base this on what a mob on social media has to say about who Jodi is, but really who she is and who she was before June 4th of 2008. I have practiced in this court for quite a while now, and I have been in here on other cases, and I have seen this court sentence many a defendant. I've seen the court take into consideration that defendant's background and the crime itself and the potential for future for those defendants. And I have sat in this court for settlement conferences, and I've seen the court handle settlement conferences where the discussion turns to what other defendants who are similarly situated get in these types of cases. So I know that the court takes these things into account when deciding sentencing. And that's the appropriate way to do it. That's what justice is. Justice requires equity. And sometimes equity isn't what victims want it to be. This case has been different from others, not because of the type of case, not because of what happened, but because of the strange attraction that it has caused for so many. This court has the experience to know the difference between a lynch mob from social media and their requests, and I'm not referring to the victim's judge, just so we're clear, and equity in sentencing and what is just and what is fair. This is a difficult decision. I don't in any way think this is a light decision at all. The facts are gruesome, and for 2 minutes what Jodi did was horrible, and the pain that she caused was reprehensible. But this case is no worse than so many other cases that have come before this court and many other courts in Maricopa County. And what happened in those cases where those defendants received the possibility of release. It is only a possibility. It's not even a guarantee. It is just the possibility, a hope to live for. We're only asking the court judge to give an equitable decision and a reasonable decision and a decision that is fair in light of the facts of this case. Based on that, Judge, we are asking the court to sentence her, Miss Arias, to the possibility of release. Thank you.
All right. Is there any legal cause why sentence should not be pronounced?
Mayor.
The court has considered the nature and circumstances of the offense. I have considered the aggravating factor found by the jury. I have identified aggravating and mitigating factors and considered those factors in arriving at a sentence for Miss Arias. As aggravation, the court finds, as the jury found, the crime was especially cruel. The offense was committed with at least 2 deadly weapons, a gun and at least 1 knife. The crime involved substantial planning and preparation. The defendant did not render aid to the victim. The defendant destroyed evidence at the crime scene. The defendant went to great lengths to conceal her involvement in the crime. The court has also considered, as an aggravating factor, the emotional and financial harm to the victim family members. As mitigation, the court finds the defendant has no prior criminal history. The defendant has family and community support. The defendant has mental health issues. The court has also considered the defendant's childhood background, family history, and her expressed remorse. The court finds the mitigation presented is not sufficiently substantial to call for leniency and that a natural life sentence is appropriate. It is ordered the defendant shall be incarcerated in the Department of Corrections for the rest of her natural life with no possibility of parole. The sentence shall begin today. The defendant shall receive credit for 2,463 days of pre-sentence credit. It is ordered the defendant shall pay a $10 probation surcharge assessment. And as previously stated, the court is retaining jurisdiction over restitution. Ms. Arias, you have 20 days from today to file a notice of appeal. You have the right to have an attorney represent you. If you cannot afford an attorney, one will be appointed for you. If you cannot afford the necessary records and transcripts, they will be provided for you at no cost. Do you understand?
Yes.
Counsel, is there anything else for the record?
No, thank you.
No, Your Honor.
Your Honor, I would be moving to withdraw at this point in time a reconsideration of April 4th, 2011. That order contemplated joint representation because it was a capital trial pending trial at that time. Given that that is no longer the case, Ms. Harris has been sentenced to life moments ago by this court. I see that there's a few ancillary issues remaining, but the motions for which motion should be filed. But pending that, I would ask that I be withdrawn from restitution hearing or any future matters, particularly given Ms. Arias's choice to be non-communicative with me. I believe it would be best for Ms. Wilmot to handle that, and so I would ask that my motion to withdraw be granted here this morning.
All right, the motion to withdraw is under advisement. Anything else? We are adjourned.